Not asking us to dance because I would have been miserable. Pakistanis are bad dancers, and I'm among the worst. I don't think we will have to shorten your lunch break. I'll make sure that I don't take unnecessarily long duration to address some of the issues that I have recently started working on. But let me clarify that I am addressing you instead of another much more competent and experienced lawyer who was supposed to be here and introduce you to the public interest litigation in Pakistan. I wish he could have made it to JNU and India. His name is Asad Siddiqui, and he has recently written, and he is actually doing a book on public interest litigation and recent developments. I am also working on along the same lines. I think copies of a section of my work have already been distributed among at least 10 to 15 of the participants sitting here. Am I right?
Yes, sir.
Okay. So I don't think I have to go through all the aspects that I have tried to. I'm still trying and trying to grapple with the development that has been taking place in Pakistan. A lot of things that Professor Matthew talked about public interest litigation in India are also true for Pakistan. So far as the development of PIL in Pakistan is concerned, a lot of our cases, actually almost all our PIL cases, refer to Indian judgments, which is a great idea, I think. But I think we have, in recent years, our courts have crossed the limits which have been put in place by the Indian Supreme Court in recent years. The principles and rules that Indian Supreme Court has established in broad terms have been followed in Pakistan during late 80s and 90s, but post 2005 I think there has been an extraordinary effort to cross those limits which Indian Supreme Court imposed on itself in various judgments. I'm not going to refer to all those judgments and burden you with unnecessary amount of citations. But we can, get together all those judgments, and some of the judgments have been referred to in this 10 or 11 pager that you have already got. We can circulate this small section on which I'm still working and will be working over the next few months. I started writing this piece a few months back, but have not been able to give it enough time. And as I said, that I am not just a pro bono litigator, lawyer, but I also do some civil and corporate practice. It's as I told you that I am a recent convert to pro bono work, human rights work. I think we can start with that presentation. And, I have tried to convert some of the ideas that I have referred to in my piece on this PowerPoint. As Professor Matthew cursorily referred to the politics of public interest litigation, I am also more interested in understanding and theorizing, which I have yet to do, the nature of the judicial politics of public interest litigation in Pakistan. But let me start with a brief overview of the powers of the Supreme Court and the High Courts in Pakistan. I think a very cursory introduction is good enough for the time being. You can later on discuss with me, and we can, exchange views over email or otherwise. There are two important constitutional provisions in Pakistan which are important, so far as public interest litigation is concerned. And one is Article 184, Subclause 3, and the other is Article 199. Article 199 is for the jurisdiction of the high courts in Pakistan. And Article 184.3 specifically refers to the powers of the Supreme Court. Now, I will be concentrating on Supreme Court's jurisdiction and the public interest litigation happening in the Supreme Court. I will not go into the history of the public interest litigation since late 1980s and through 1990s, but I will refer to the recent trend that we are witnessing in Pakistan's Supreme Court as regards public interest litigation. So Supreme Court and High Courts have certain kind of jurisdiction so far as enforcement of fundamental rights are concerned. The High Courts have jurisdiction under Article 199 of the Constitution to enforce fundamental rights under Clause 2. Article 184.3 is a radical provision which is parallel or comparable to the comparable provision in the Indian Constitution. And under Article 184.3, any party can petition to the Supreme Court as opposed to Article 1021 of the Constitution of Bangladesh. And this is something I discovered only last night when I was speaking to one of our delegates from Bangladesh, Mehboob, and I am forgetting the other name, Ms. Nasreen. Yeah. And Article 126 of the Constitution of Sri Lanka, which mandate applications by aggrieved parties only. I am unaware about the jurisprudence and the interpretation which has taken place as regards the words aggrieved party are concerned. In Pakistan, so far as the jurisdiction of high courts is concerned, aggrieved parties can petition to the High Court, but the meaning and the interpretation of aggrieved party has been so made over the years that the scope of being an aggrieved party has been extended, and actually any interested party may petition to the High Court for the enforcement of fundamental rights. There are some details. I don't think I have the time to go into that, so we can discuss that too sometime later maybe. So far as Article 184.3 is concerned, it empowers the Supreme Court to issue orders in matters of public importance in order to enforce fundamental rights. Now, anyone can petition to the Supreme Court for the enforcement of fundamental rights in any matter of public importance. And what are the fundamental rights? Fundamental rights are the ones which have been enumerated in the Constitution of Pakistan under Part 1, Chapter 1 at the beginning, which is Articles 8 to 28. And what are those fundamental rights? Those are almost the same as they are enumerated in the Indian Constitution: right to life and personal security, freedom of speech and right to information, freedom of assembly, human dignity, which includes right to privacy, freedom of association, freedom from discrimination, right to fair trial, protection against double punishment and retrospective punishment. So courts can issue writs in the nature of habeas corpus, writs of mandamus. High Court under Article 199 can issue writs of prohibition, mandamus, certiorari, and that is possible on the application of any aggrieved party. And so far as writs of habeas corpus and quo warranto are concerned, they may be filed before the high courts by any party. Any party. That's how it is described in the Constitution. But as I said, that under the interpretation of Article 199 as regards the aggrieved party is concerned, it has been done in such a way that aggrieved party is now almost simultaneous or same as any party. So the classical requirement of locus standi of being personally aggrieved in some way is no more there to be shown. So far as Supreme Court's jurisdictions are concerned, as I have just mentioned, that under Article 184(3), Supreme Court can take notice of matters of public importance for the enforcement of fundamental rights. Then there are two other jurisdictions which Supreme Court of Pakistan enjoys, which is, and this jurisdiction under Article 184(3) is original jurisdiction, and then there is appellate jurisdiction of the Supreme Court of Pakistan, and there is also the advisory jurisdiction. Appellate jurisdiction, of course, means that cases which have been decided by the courts below are appealed against before the Supreme Court of Pakistan, and the advisory jurisdiction is invoked by the state institutions, and which includes the government of Pakistan, the governments of various provinces. So, having said that, let me also mention that Article 8 prescribes that any law which is contrary or in violation of any of the fundamental rights may be struck down. So Supreme Court in its original jurisdiction can issue writs of various kinds and also strike down laws enacted by the Parliament or any provincial state legislature, or for that matter, any executive authority, rules issued by any executive authority which are in violation of the fundamental rights may be struck down. The issue that I am trying to understand for past few months is that how is it that Supreme Court of Pakistan advancing the cause of human rights? I think there are a number of issues which are generally ignored, and I think lawyers, being the holders of rule of law and champions of law as such, should not ignore those issues. I think that Pakistan Supreme Court in particular and high courts generally have been transcending the jurisdiction that have been